Sir, I'm not going to argue with you.
I'm just asking for clarification. I'm not going to sign.
If you're not signing, then I have to take you into custody.
I'm scared when he does this sentence, he's going to get out and finish what he started. I still have nightmares from how this man treated me and how he used to stomp and beat me for no reason.
Colton Washlow was not forthcoming with his name. When he pretended not to know what I was asking, he claimed that he did not know how his name would show in our system.
Board, would you like to enter pleas at this time?
No.
Well,
Yeah, I don't understand. If you're able to enter in a plea for me, then I shouldn't have another court date.
yeah, well, that's not how it works.
This one takes a sharp turn. First, we got a sovereign citizen who genuinely believes traffic laws only apply if you personally sign some imaginary contract. He walks into court acting like he unlocked a secret level of the legal system. Chest out, confidence high, right up until the judge reminds him how actual authority works. And then everything changes, because the next case isn't funny at all. We go from internet lawyer comedy to a domestic abuse case where the victim delivers one of the most chilling impact statements I've heard in a long time. 2 hearings, 2 very different realities. Let's dive in.
False statement to a public servant is the charge on 563, and driving suspended 3rd degree is a charge on 562. And Mr. Waslum, if I'm correct, you don't want an attorney to assist you with arraignment here this morning?
I will be standing on as my own counsel.
Okay.
I've appointed myself as my own counsel, and I'm ready to proceed with administrative procedural matters.
Do you want to hear a formal reading of your rights?
Sure. But they would be not all limited to those rights, right? There would be more that are not included, right?
With what?
The rights you're about to read, it's to my understanding that there's more than just those rights. I was just making it on the record that
start with rights, and there's actually a written version if you want to review it.
well, there's the written version, but there are more rights to that. It's not just limited to those rights.
Those are your constitutional rights, and it's a summary of your
That is
rights.
not limited to that.
Do you want to review it in writing, or we have it on paper, we have it on the computer?
You can review it, I guess. Yeah.
Okay, so you want the court to read it out loud
Sure.
rather than review it on
Yes, please.
writing? Okay, let me get to that document. You have the right to be represented by an attorney of your own choosing at all proceedings. And if it's determined you cannot afford an attorney after screening, you'll be appointed one if you want one. If you don't waive your right to an attorney, even if you don't have one at arraignment, you don't waive your right to a later proceeding having counsel. You're presumed innocent of any charges until it's proven beyond a reasonable doubt. If you do want to waive your right to a jury trial, then it would be set before a judge without a jury. And you have the right to call witnesses on your own behalf. If they don't come voluntarily, the court can compel their appearance to testify. You have the right to testify on your own behalf. And then if you feel you cannot have a fair trial because of bias or prejudice of a particular judge, you have the right to ask for a different judge within 10 days of the actual notice of assignment to that judge. That would be for a trial. You're only entitled to one change of judge. If it does go to trial, you have the right to appeal if there's a finding of guilt following the trial by judge or jury. Do you have any questions about these rights?
No.
Would you like to hear the police report read out loud for a determination of probable cause?
Sure.
Officer Bayrat was Arragad Sandoval. I butchered the last name. On 8/18/2025 at approximately 0328 hours, I was on routine patrol in the downtown area. I saw a black VW Jetta with Washington plate BKL0099 switching lanes multiple times. I ran the plate on my MDT and it showed that the registration was expired. I activated my lights. The driver, later identified as Colton Waslow, kept driving for several seconds. He pulled into an alley on the 600 block of East Chestnut Street. I approached the vehicle. The driver cracked the window about an inch. I informed the driver I pulled him over for his registration being expired. Colton Waslow stated that his registration was not expired. I advised him that DOL was showing his registration expired in June of 2025. I asked the driver for his documentation. Colton Waslow stated all his documents, including his driver's license, were in the trunk of the car. I asked Colton Waslow to tell me his name, date of birth. He claimed it was Colton James. He asked if I wanted his family name. I replied multiple times that I needed his name the way it appears on his driver's license. He said that is how it shows. I ran his name through dispatch and it came back with no results. Officers ran the registered owner of the vehicle, Crystal Bennett Burgess. through long arm. She showed history with a Colton Washlow. Officers ran the name through DOL and matched the photo to the person driving. I ran Colton Washlow's name through dispatch once more. Dispatch advised that Colton Washlow's license was suspended in the third degree. Due to Colton Washlow's driving while suspended in the third degree, probable cause existed for his arrest. I informed Colton Washlow that he was driving suspended and I needed him to step out of the vehicle. He got out and I placed him in handcuffs with no incident. I checked the cuffs for fit and double locked them so they would not close around his wrists. I searched Colton Washlow, incident to arrest, found his driver's license in his left pocket. I read Colton Washlow his constitutional rights from my department issued Miranda card. I cited Colton Washlow for driving suspended license. For driving suspended license third for driving on a suspended license. I cited Colton Washlow for making false statements to a public servant. Colton Washlow was not forthcoming with his name when told he needed to provide law enforcement with his identity on a traffic stop. After asking Colton Washlow multiple times for his driver's license, he pretended not to know what I was asking and ultimately provided the name Colton James. When asked if that was the way his name showed on his driver's license, he kept saying he was not in commerce. He claimed that he did not know how his name would show in our system. Colton Washlow kept stating his family name was different than what he gave me multiple times. Due to Colton Washlow's claiming his driver's license was in the trunk of his car when it was actually in his pocket and providing a different name than the one on his driver's license after being asked several times if it matched his identification. Colton Washlow, knowing his license was suspended, it is reasonable to believe that Colton Washlow was purposefully not providing his legal name for the purpose of misleading officers. This occurred in the city of Bellingham, state of Washington.
Anything further on the sworn testimony?
No.
The court finds probable cause is established for these two charges to go forward. Would you like to enter pleas at this time?
No.
Well, it's either guilty or not guilty.
I'm innocent.
Not guilty pleas are entered on your behalf,
Well, then,
preserving all of your defenses.
I mean, if you're going to enter a non-guilty plea on my behalf, then if you think I'm not guilty, then I'm not guilty and we're good. It's dismissed or...
This guy honestly thinks that when the court enters a not guilty plea on his behalf, it means the judge agrees with him and he gets to walk out. No, sir. That is not how arraignments work. At all. He's standing there like he just outplayed the entire justice system. Like the judge accidentally admitted defeat. The confidence is loud, but the understanding? Almost non-existent. And you can literally see the judge clock it in real time. Oh, this is going to take longer than it should.
City want to be heard on release?
Asked that Mr. Washlow be released on his personal recognizance.
Are you going to entertain it?
Not guilty pleas mean you preserve all your defenses. If you want to bring motions, that's up to you.
I'd like the motion for dismissal.
You need to follow all of the criminal rules of law. If you don't want an attorney to assist you with that, then it's on you to research.
I didn't give a plea. I'm not going to plea in the court today. I don't want to be any part of this.
The court's entered a not guilty plea on your behalf, both charges.
So then it's over. We're good?
You're released on your personal recognizance. Conditions of release. Please conduct yourself lawfully. Don't pick up any new criminal charges while released on these. Do not drive without a valid license, proof of insurance, part of lawful behavior. And your presence is required at your next court hearing, which is a pretrial that's set for October 10 at 1:30.
Yeah, I don't understand. If you're able to enter in a plea for me, then I shouldn't have another court date.
Yeah, well, that's not how it works. The plea just preserves all your defenses. It's not a finding. And there's no final adjudication of not guilty here.
But the rights that I have that you read out.
Would you like to apply for a public defender to help you?
I'm just wondering why the rights that you had said and had read out said that I'm presumed innocent until proven guilty. Why would I have to enter a not guilty or guilty plea if I'm innocent until proven guilty by that statement?
Sir, I'm not going to argue with you.
I'm just asking for clarification.
Clarification is you have entered, or the court on your behalf has entered not guilty pleas because you don't wish to plead guilty.
So then it's been
dismissed. Which preserves all your defenses, and the city needs to then prove the elements of the crime in order to have a finding of guilt. Or if they can't prove it, not guilt.
But if the court puts...
Sir, I'm not going to argue with you. I'm
just trying to clarify.
Your pretrial release order is ready for your review and signature. Would you like the documents printed, emailed, or both?
I do not wish to contract with the court.
Emailed, printed, or both?
You do whatever you would like, but
No, I'm asking you. Do you want them printed, emailed, or both?
I'm not going to sign.
If you're not signing, then I have to take you into custody.
Now watch how fast everything changes. The second custody gets mentioned, that sovereign citizen confidence evaporates. Instantly. A minute ago, it was contracts, consent, jurisdiction. Now, suddenly very polite, very cooperative. And that's always how it goes. The philosophy lasts right up until someone says the word jail. Funny how fast I don't consent turns into, yes, Your Honor. It's almost predictable at this point.
Instead of bail them out. So it's easy if you want to sign. You're not giving up any of your defenses.
Well, but you're entering in a plea for me when I'm still not understanding what's, if you, the court, say that I'm not guilty.
No, what I said is I'm entering a not guilty plea. I'm not finding you not guilty.
Okay, but why not just put down innocent? I'm not pleading.
Here, I'll put down innocent on the bottom, that you're asserting that you're innocent of these charges. If you
Okay.
can get out of the signing part, please. I've put that information in the form for your review, and now it's ready for your signature. And once it's signed, would you like it printed, email,
please.
or both?
Yes, please.
Yes would be both.
Yes.
Okay. You're also being provided the essential elements of the crimes. So first, Madam Clerk is printing these up. Here's one more. And then she'll also email them to you.
Cool. Thank you.
Once you have your paper copies from the officer, you're free to go.
Thank you.
Thank you.
Mr. Davis, good afternoon, sir. The last time we were here, we went through a few questions. You decided to exercise your right to self-representation. That's still your decision?
Yes, sir.
Okay, but where are we at in your cases?
Going to trial.
Okay, we already have the matter set for trial, Madam Clerk.
Yep.
Yeah, we have you set for the on the February 24th trial docket. So what we'll do, we'll bring you back for a trial management on February the 6th at 9:30, and that will be the plea and discovery cutoff. Basically, you and Mr. Patterson will have your last not preliminary, but last plea negotiations. And if the case isn't resolved, we'll select your jury on the 24th, Mr. Davis. All right, take care. We'll see you then, sir. Mr. Way.
Good afternoon, Your Honor.
Good afternoon, Mr. Williams. This is Mr. Henry Davis.
Yes, sir. We have two case numbers, Your
All
Honor.
right, tell me what's been going on with Mr. Davis's case.
Your Honor, I had plans to see Mr. Davis this weekend down in Franklin, and I had a little automobile problem, wasn't able to see him. I have Thursday. He's on my calendar for Thursday for me to visit him. And it's really to go over those medical records that he has expressed a concern about before. And I've also initiated some conversations with Mr. Patterson, and he has a few little details he has to take care of before we can really get involved in any possible negotiation. So if we could have one more pretrial conference. I understand we don't have a trial date, or you don't have a trial date until May, I believe. So if we could come back sometime before that, so we can let you know if we're going to be able to resolve it or continue and go to trial.
All right, let's go ahead and place Mr. Davis on the May trial day. He's been in custody for a very long time. That will be May 19th, but let's come back April 1st at 1:30. See where we are after your meeting. And I believe you said on Thursday, 2 days from now?
That's correct, Your Honor.
All right, perfect. So I know you have a meeting on Thursday. We'll see you April 1st at 1:30.
Very well. And I assume Mr. Davis is still going to be in Franklin County Jail there. That's where I'm planning on meeting.
I'm being told, yes, Mr. Davis will be in Franklin County.
I thought so. Okay, thank you, Your Honor. And that's the only matter I have before you, if I could be excused.
You may be excused. Thank you, Mr. Williams.
Thank you, sir.
Mr. Williams, how you doing, sir?
Got Henry Davis, Your Honor, two case numbers, 24 CF 42 and 24 CF 59.
All right, Mr. Davis, how you doing, sir?
Your Honor, we're presently set for trial on May the 19th. I've had a chance to meet with my client, the investigator has as well, and has some discussions with Mr. Patterson. So I still hold out hope that we come to a resolution.
Absolutely.
So, and I'm not sure about the status of the 5/19 date. I'm sure you're aware of that. So I
Yes, sir.
think best we just leave it there right now.
Absolutely.
If something develops, we come up with a resolution. We know how to get on your docket.
Yes, sir.
Otherwise.
Let's come back May 8th
May the-
for trial management. And that way we can talk about if there's any last minute plea negotiations or plea offers, any motions in limine or anything we need to discuss. And of course, you can appear by Zoom, Mr. Williams. So that'd be May 8th at 9:30. And
Your Honor, I know Mr. Williams is aware of this, but just so everybody's on the same page, we will be proceeding on 2442 CF first.
That's
okay.
good to clarify that, but that's what I figured. Yeah.
All right. Thank you, Mr. Williams.
Thank you.
Thank you, Mr. Davis.
Good morning.
Good morning, sir. How are you?
I'm fine. Better than I appear. Your Honor, today we're with State of Florida versus Henry Lee Davis III. Two case numbers, 24 CF 42 and 24 CF 59. Mr. Davis today is going to withdraw his previously entered not guilty plea and plea no contest in case 24 CF 42 to count one, which is felony battery, a third-degree felony punishable by 5 years in Department of Corrections and or a $5,000 fine. He's also going to plead no contest to count 2 in that case, to resisting officer without violence, which is a first-degree misdemeanor punishable by 1 year in the county jail and a $1,000 fine. In exchange, he's going to be adjudicated guilty. He will be sentenced to 50 months in the Department of Corrections. If there is any restitution, we're going to reserve on that. We'll set a hearing later. He will receive 434 days jail time credit. There'll be time served on that misdemeanor, which is count 2 of 24 CF 42. He'll provide a DNA sample of forfeit seized items, and the state has agreed to null pros 24 CF 59.
Yes, sir.
And I'll pass that up. And I believe
Mr. Davis, you'll raise your right hand for me, sir. Did you hear Mr. Williams' announcement about how you're going to resolve your cases? Given the influence of any alcohol, drugs, or medication?
I'm on meds.
Yes, sir. I believe your medication, I want to say, helps you in your behavior and ability to think, but it doesn't affect you negatively in your ability to think, correct?
No, sir.
You understand what's going on today?
Yes, sir.
I know you do. You're highly intelligent, but there needs to be a record of it so I can find that your plea is voluntary and intelligent into. Mr. Davis, you're waiving your right to a trial by jury. I believe. I'm sorry, go ahead.
Stipulate that there's no DNA evidence we're aware of that would tend to exonerate or exculpate my client, and we'll waive any formal reading of the costs associated.
Thank you. And Mr. Patterson, I believe you said there's a.
Yes, Your Honor, my office has been in contact with the victim. She is in agreement with this resolution, Your Honor. I do not know at this moment whether she wishes to address the court or be heard, but she is present if she wishes to do so.
All right, ma'am, would you like to be heard before I pronounce sentence?
Yes, sir, I would.
Oh, go ahead. All right, Ms. Clark, what do you want me to hear, ma'am, before I pronounce sentence?
I believe Mr. Henry Davis does not need to get any time served. Me and my kids are still terrified of him. My kids still have nightmare because he threatened to kill my kids. I'm scared when he does this sentence, he's going to get out and finish what he started. I'm scared, like I'm shaking now. I do not want him any time served at all. I'm petrified of this man. I still have nightmares from how this man treated me and how he used to stomp and beat me for no reason.
And then the room shifts completely. The second case starts, and the humor disappears instantly. The victim begins speaking, calmly, clearly, describing what she lived through, the fear, the control, the damage. And suddenly, none of the jokes from earlier matter anymore. This isn't word games. This isn't courtroom theater. This is real trauma, spoken out loud. Moments like that remind you exactly why sentencing exists in the first place.
I don't know what you got your head down for. You had it up. Have it up now.
Ma'am, you have to just, Mr. Davis, don't
I'm
go there.
sorry.
Ma'am, it's fine. Just address your comments to the court, not Mr. Davis.
I'm sorry. I've been quiet for so long. I don't know what to do. Please just do not give him time served. Please. I'm scared of him. And I understand he's going away, but still that time served is going to lower it.
Yes, ma'am. Anything else?
No, sir. That's it.
Anything you want me to consider, Mr. Davis? Do you want to be heard on anything?
No, sir.
Okay. Well, I'm going to accept the plea. I'm going to find that it's known, intelligent, and voluntarily entered into. In case number 24 CF42, you'll be adjudicated guilty of felony battery. And that's priors, correct?
Yes, sir.
Okay. I know that.
His charge is bodily harm.
Bodily harm? Okay.
It's a level 6.
Perfect. All right, and resisting officer without violence, a misdemeanor, you'll be sentenced to 364 days on count 2. The resisting the officer without violence and given credit for 364 days on count 2. On count 1, the felony battery, you'll be sentenced to 50 months in the Florida Department of Corrections. You've been in jail for 434 days. You're entitled to that jail credit, and you'll be given credit for 434 days. You must provide a DNA sample, forfeit seized items, and there will be I'm going to add a no contact. There'll be no contact with the victim or the victim's family. Have any questions, Mr. Davis?
Sir.
And the state agreed to dismiss or no pros case 24 CF 59.
Your Honor, this time the state will announce a null pros in that.
Perfect. All right, Mr. Davis, best of luck to you. You've done at least in court, done a complete 180. Stay on yes. And you have court costs and fines. Do I have that sheet? $1,357, and Mr. Williams has waived my reading discretionary costs and fines, and that would be reduced to a civil judgment. Mr. Davis, best of luck to you. You got 30 days to appeal the judgment and sentence, and if you can't afford an attorney, we'll provide one for you. Yes, sir.
One other thing I forgot to mention, Your Honor, he would appreciate a recommendation from you to go to a DOC facility somewhere near Tallahassee, which is sort of centrally located for his family.
What's the app? Is the app? Guess it's for ladies. Is that Appalachia?
Appalachia is in Sneeds, yes, Your Honor.
Is there any other near Tallahassee?
I think there's one.
Jefferson.
Okay, and I'll recommend Appalachia or Jefferson CI or any facility near Tallahassee.
That's right.
Thank you, sir. Thank you, Mr. Davis. Best of luck to you, sir. Thank you,
That's
Mr.
all we
Williams.
have.
The first guy was embarrassing. The second guy was dangerous. And that contrast matters. Because while some court hearings feel like a circus, others are about real people just trying to feel safe again. Yeah, the justice system isn't perfect. But in cases like this, you hope it does what it's supposed to do. So let me ask you, do you think 4 years was enough for what you described? Drop your thoughts in the comments. And as always, thank you so much for watching. Make sure to like and subscribe, and I'll catch you in the next one.